So, last meeting we discussed on the provisions under Rule 126, which dealt about searches and seizures. So now you know that for you police officers, in order for you to able to search a home and seize certain items from that building, you need to secure first a search warrant. That is the general rule. Now, I forgot to mention last time, Section 7, di ba you have the right to break the door or window to effect search. Now, for example, the officer, before he breaks that door or breaks that window to effect the search, he has to give notice to the occupants of that building or that of that building of his purpose and authority. He has to knock and shout his purpose and authority. That's what you call the knock and announce rule. So you knock and announce. And announce means you announce what your purpose is and your authority as a police officer. So please don't forget the knock and announce rule. Today we will be discussing on, we discussed on searches and seizures with a warrant. But now we will focus on searches and seizures without a warrant. So we call this warrantless search or warrantless seizure. Okay, so warrantless search. When you say warrantless search, what comes into your mind? Mr. Rizado.
Okay, sir. So, for me, sir, example ng warrantless search is yung on hot pursuit, sir. Example, sir, yag-conduct ng checkpoint tapos every kwan, sir, meaning every sakyanan, sir, pahunungon lang kay i-search nila, sir. I-search
Okay.
nila kung kuan.
In English,
Lang, sir, example ko, sir.
So in English,
So
your example is involving those that
example,
involves.
sir. Example, that there is conduct of checkpoint.
Okay.
And in the PNP are the PNP are checking all the cars or all the example ban, just like, sir, example ban, they conducted checkpoint without warrant.
Okay, thank you, Mr. Rizado. Yes, actually,
Welcome, sir.
Mr. Rizado is correct. So when you say the word warrantless search, these involve searches that do not involve a warrant, and the most common warrantless search is at those that involves your checkpoints or this is
By bus
heavily
operation, sir. By bus operation, apel.
By bus operation. Pwede, because when you say by bus operation, you arrest an individual and you search an individual without a warrant. Yes, that is correct also, Mr. Valeroso. Right. So those are just a few of your sample warrantless searches. So let's deal with the laws that involve warrantless arrest or that involves warrantless search, so that you'd be able to so you have knowledge about it, so that you can apply it in the real world when you become police officers. And mind you, this is a very important subject, to the point that this is really asked in the board exam. Now, the first warrantless search is this type, when the right is voluntarily waived. So When you waive, meaning, okay, ma'am, pwede ko mag-search sa imong bag, niuyon ka. So that is voluntary waiver on your part because you said yes to the warrantless search. Now, according to the Garcia versus Locsin, for the valid waiver of a constitutional right, it must appear first that the right exists. Second, that the person involved had knowledge, either actual or constructive, of the existence of such right. And thirdly, that the said person had actual intention to relinquish that right. So, for this type of warrantless search to be applicable, you have three requisites. First, it must appear that such right is present, meaning nakikatungod na buo yun sa search. Second, kabalo ka na, kanina knowledge nimo is, kabalo ka na I may opt to waive this or I may opt not to waive this right. And this right is existing. And lastly, tungod kabalo ka na naakay right, pwede po din mo siya i-relinquish, pwede po siya din mo i-give up. So these are your valid waivers of a constitutional right under the doctrine laid down in De Garcia versus Locsin. So, in order for you to waive your right, the consent must be voluntary. Meaning, gikan gyud sa imuha, wa ka gipugos, wa ka gi-intimidate, wa ka gi-terrorize. And it has been intelligently given by you and uncontaminated by any duress or coercion. Meaning, wa ka gipugos na i-give up ang imuhang right to be searched. Now, you have here in People versus Umawing, 213 Skra 6462, the accused during a vehicle was stopped at the checkpoint. And when the vehicle was inspected, the soldiers asked permission to see the contents of a bag, which was partially covered by a spare tire. So the accused here consented to the search, and the bag was found to contain marijuana. According to the Supreme Court, valid ang search sa soldiers. Why? Because you voluntarily waived your right to the search. Niuyon man ka, sige, tanawa tong akong bag dito. Pagtanaw sa soldiers naman di ay marijuana. So, the search is valid, the seizure is valid, and the evidence is also valid because it was obtained validly through a warrantless search by means of waiving your right to such search. Now, in People versus La Serna, the occupants of the taxi cab consented when the policemen sought permission to search the vehicle. Mogyapon. Walay nag-ingon na Supreme Court dire na since ni oo mo sa search, gipatanaw ninyo ang policeman sa pag-search sa inyong vehicle, then gi-waive ninyo inyong right. So anything na contraband na makit-an diha can be used against you and may be held against you. Now, in People versus Korea, the police officers here informed that the accused would deliver marijuana. So, they followed the accused and later accosted him, and one of the policemen opened a tin can in the jeepney of the accused, but the accused did not protest. The Supreme Court held that there was consent. Again, when you say you have a right to of such, you have the right to waive or not waive, aware ka na kay right, di ba? So kung i-search imuhang bag, wa ka ni protesta, wala ka na ingon oo dili, wala tanaw na nimo siya, gihayaan na nimo siya na mutanaw si imuhang bag. That is already constructive waiver, meaning impliedly gi-allow na nimo ang imuhang consent to be searched. So be careful. Kung i-search ka na imuhang bag, ingon mo no, or dapat mo, oy, ingon ka, bawal na, wala kay search warrant, you have to address your right, or you have to exert your right against involuntary searches and seizures. Naklaro ang first type of warrantless search?
Yes, sir.
Yes, sir.
Okay. So, daghan man checkpoints diri sa tuang area. If you can recall, di ba, sa may San Antonio ata to sa una, diya sa may doon sa bridge, kanang Taytayan Bridge ba na? Or kanang sa
Papag, sir, sa Papag.
Great Katiil River diha kana. So you can always exert your right na, for example, amoy bag. Kunya, tingnan mo, abrihan na imong bag. You can always say, no, I am exerting my right against warrantless search. Ya, babataan mo, na siya tulot sa inyo ana ina si Fiscal Monday, agi na mo dahil. Joke lang. Pero ang problem mo gud sa tua if although this right exists, ang problem mo gud sa tua if we don't allow our bags to be opened, mag-raise og suspicion ang mga kaning mga soldiers or mga police officers. So dapat dili man gud ingana. Dapat maglabaw gyud ang inyong right not to be searched without a warrant. Right, next is your searches of passengers at airports. Nga naman, remember that airports are of public destination, meaning daghang tao. So when you say daghang tao, there is a risk to public safety. So in People versus Gatward 267 SCRA 785, it was held that when the accused checked in his luggage as a passenger of a plane, he agreed to the inspection of his luggage in accordance with customs laws and regulations and thus waived any objection to a warrantless arrest. Remember, sa airports, daghang bomba diha, daghang criminality diha. So, there is really a need na i-search ang imuhang luggage. So, the searches under airports is allowed because public safety ang kalaban nimo eh. So, when you try to weigh your rights, di ba, you have the right to privacy, meaning you have the right not to allow them to open your bags, as opposed to the right to public safety. Asa man mas bugat? Privacy nimo o ang public safety sa tanan? Syempre, mas bugat yun ang public safety. Mauna, gina-allow ang searches of passengers at airports. Klaro?
Yes, sir.
Okay. Now, in Aniag versus Comelec 237 SCRA 424, the Supreme Court said that in the face of 14 armed policemen conducting the operation, driver Arellano, being alone and a mere employee of the petitioner, could not have marshaled the strength and the courage to protest against the extensive search conducted on the vehicle. Consent given under intimidating or coercive circumstances is not consent within the purview of the constitutional guarantee. Ito yung pasabot sa Supreme Court, ani. Si Arellano nag-drive og car. Kunya gi-stop siya sa isa ka lugar. And ang nag-stop siya were 14 dili lang policemen but armed policemen. So hadlok gyud kaayo. So kung mangutana sila, pwede nimo abrihan imuhang sakyanan alangan sa kahadlok nimo, muog gyud ka, di ba? But because they were armed and napauo na lang ka, this is not the consent na ginaingon na mualaw ka to a search because you were intimidated. Because of this nga, the presence of the 14 policemen mas armed pa gid sila. Dapat manggod, consent must be given not under duress, meaning walay persa sa imuha, walay intimidation sa imuha ba. But in this case, there was intimidation and coercion because of the presence of the 14 armed policemen. So ingon Supreme Court, wala siya naghatag og consent niya, hence atong pag-search niyo sa iyang sakyanan, any thing na contraband na gisiz niyo diha will be illegal because he did not give his consent. His consent was under duress. Gi-intimidate ninyo si Arellano. Nakuha ang Aniag versus Comelec. Klaro ha?
Opo, sir.
Okay, when is there a valid reason to stop and frisk, also known as the Terry search? When you say stop and frisk, sir, stop, wala, kapkapan niyo siya. Another term for this is your Terry search. That's it ni siya. Search na siya, Terry search. Sorry, kasi nakatulog ko na. So, si Terry search, dito itong salida na ha, magbawa ko Terry. Salida number 2, ito siya. Lain siya na Terry. So, in People versus Manilili versus Court of Appeals, the Supreme Court said upheld the validity of the search akin to stop and frisk. Kaya gikuha man guning stop and frisk na principle sa landmark case sa United States, which is the Terry versus Ohio case. Muna, kaning stop and frisk, gitawag po nilang Terry search. As it was defined as the vernacular designation of the right of a police officer to stop a citizen on the street, interrogate him, and pat him. Kapkapan ninyo siya for weapons whenever he observes unusual conduct, which leads him to conclude that criminal activity may be afoot. So, if you are a police officer, you were told to patrol a certain area, and then you saw this individual who is very suspicious looking, and he appears to be holding something in his pocket, and there were reports already that there might be a commotion that will happen or there will be a gun shooting incident. So, niduol ka sa iya. So, wingon ka, stop whatever you're doing. I am Police Officer Manaytay, and you appear to be suspicious. You look like you're about to do a certain heinous crime. So, I am going to search you for any contraband. So, muna. So you stop and you frisk him. Frisk means kapkapan. So kapkap din mo siya, you did a Terry search and you found that gun in his pocket. So kana siya na search nimo is valid. Okay. So any questions so far regarding the stop and frisk or the Terry search?
Sir, na ako ikuan sir.
Oh.
Kaning how about kanang stop and frisk or research sir gamiton nila sa mali nga paraan. Gamiton sa mga police officer. Papa-stop sir kapkapan na butang butangan ng mga ebidensya sir ba? Ana ba?
Oo. Are you asking if this has been used by the police force in order to plant evidence? Is that what you're trying to say?
Yes sir.
Oh, actually, gibuhat na ni siya several times by the policemen. So mauni ang reason nga nigawas ang atong Administrative Matter 2106-08 or the use of body-worn cameras in the conduct of warrantless search, warrantless arrest, in the effect of search warrants, and in the effect of warrant of arrest. Ngano? Kaya there are a lot of violations, there are a lot of human rights violations committed by the law enforcement agencies. So, in order to prevent this type of planting evidence, gina-require na ron ang mga police officers to have at least a body-worn camera or at least an alternative recording device. Muna, gi-address na siya na area. Any question pa, Mr. Rizado?
Last comment sir.
Sige.
Kaning ano sir ba? Very situational good siya sir. Kaning example sir na ay tao nga nang kanang example nato sa droga sir. Surrender siya sir. Tapos kaning surrender siya then kanang kahina-hinalaan gyud siya ba sir nga nagagamit gyapon, nagatulak gyapon kuan kanang legal drugs din pag kaning stop and frisk or T-research nagkandak sila T-research sir police din plantidan nila sir. So maundor ba gyapon sa korte sir kanang inana sir.
Okay, so for example, that individual is indeed innocent, tama ba? Mao ba na imuhang target na innocent gid ang kaning tao na giplantahan nila? Hello?
Yung anak siguro pasabot ni Risado, sir.
Sir,
Okay.
excuse me, sir.
Wala yung
Ah.
signal, sir.
Wala
Sir,
yung
dali lang
signal
ako
daw,
kay
sir.
Patrick, sir, nga cellphone, sir, kay nawala akong signal, sir.
Sige. So pasabot ni mo innocent ning tawanan ni, di ba? But giplantahan lang ang unsa o evidence. Okay, so kung ingana
Dili, sir,
sila,
kaning kuan jud, sir, ba kanang surrender siya, sir. Tapos kanang nagatulak siya, sir, pero actually kanang pagkondak sa mga pulis og research, wala siya ebidensya din iplantidan. Honor ba, sir, sa kuan sa korte?
Okay. Muna, diyan na magdaog ang imong pieces of evidence. For example, kung ikaw lang isa, wa kay laing backup, you really are at the wrong place at the wrong time. Sad to say because there are a lot of cases na naingana nga giplantahan lagi sila pero wala may mo witness sa ilaha na wa man siya bitbit na ingana or wa man siya bitbit ana. So muna it's lisod gyud karon nowadays na ingana ang imong situation ba. So I suggest lang yun na you should not be involved in any way sa drugs kay para di mo maplantahan. Kay in Davao City, talamak ni siya na practice sa mga police officers. As a matter of fact, kabalo ang mga police officers na nag-push ka. But kabalo po sila na gamay lang ang imong gina-push. So ang buhaton nila, dakuon nila ang pagplanta sa evidence kay para di mo ka piyansa. Kay para di mo ka plea bargain. Murag giunsa ba, murag tungod sa imong reputation as a drug dealer in Davao City, pues kung saan pag plantahan ka na magdako ingana, which is not supposed to be the scenario ba, because that is already a violation of your human rights. That is not human rights based approach in terms of dealing with police work. So sad to say ha, you need maglisod yun ang defense ana if wala siya witness or evidence na mo counter sa planting of evidence sa police officers. Unless of course, Mr. Rezado, kaning imong ginaingon na tao na giplantahan is already a changed man. Let's say wala na siya droga, di na siya nag-use, wala siya possession. Ang magamit lang gid niya no kay kaning test for methamphetamine or marijuana sa iyang urine. Why? If you plant evidence against him, kuwaon man na yun kung user ba siya or dili. If he tests negative, that will already raise doubt on the part of the judge. Na lagi siya drugs pero nganong negative siya. So that will already raise a doubt on his part. So kana, I hope na-address na kayo mong pangutan na Mr. Rizado.
Yes, sir. Salamat kayo, sir.
Okay, no problem. All right, in People versus C. Chua, the Supreme Court said that the stop and frisk situation, the police officer should properly introduce himself and make initial inquiries, approach and restrain a person who manifests unusual and suspicious conduct in order to check the latter's outer clothing for possibly concealed weapons. So when you are about to stop and frisk and do the Terry search, you have to introduce yourself as a police officer and state to them your initial inquiries, kung mga bangutan na kasi ilaha. Then mo nang isa sa mga requirements for you to conduct your Terry search. So the apprehending officer must have a genuine reason in accordance with the police officer's experience and the surrounding conditions to warrant the belief that the person to be held has weapons or contraband concealed about him. It should therefore be emphasized that a search and seizure should precede the arrest for the principle to apply. So say pasabot ani, in order for you to stop and frisk a person, dapat mag-una yun ang arrest. Hindi pwede search ka then arrest. Unahon sa gini mo ang arrest sa you appear to be suspicious. So I'm going to arrest you. Warrantless because you appear to be suspicious. You have red eyes. You appear to be touching your pocket area for something. So I'm going to arrest you. So mo na gingon na you have to make your announce your authority and make your initial inquiries. So mo na diyan ka pwede magkap-kap sa iya. Wala lang pasabot sa people versus see through. Okay. Muna yung ginaingon ni B-Boy ganihan na by bust, where the search and seizure is an incident to a lawful arrest. Meaning sa by bust operation, kaning police officer would serve as the buyer and the accused as the seller. So pag by bust, pagpalit, pag-exchange sa money o sa prohibited drug, dapat na exchange of money ha, kay or else that will not be called a sale. Kaya ang ginaingon ba, for you to be convicted under 9165 for selling, dapat mubaligya ka and dapat nabud kay kwarta na ikahatag. So dapat mao na exchange yun na dapat nakuha ni mo ang kwarta, nakuha niya ang kwarta and nakuha ni mo ang droga. And that's the time you make an arrest. Pag nag-exchange siya gani, i-arrest rin mo siya warrantless. And pag na-arrest rin mo siya warrantless, that is already the time for you to search and seize him for other drug paraphernalias or other contraband na mga items. So mo ni ginipasabot na search and seizure incident to a lawful arrest, meaning nauna ang arrest before ka nag-search and seizure. So a person lawfully arrested may be searched for dangerous weapons or anything which may be used as proof of the commission of offense without a search warrant. So in People versus Estelia, the Supreme Court said that the prevailing rule is that of the officer may take from the arrested individual any money or property found upon the latter's person, that which was used in the crime or was the fruit of the crime, or which may provide the person arrested with the means of committing violence or escaping, or which may be used in evidence in the trial of the case. The search must, however, be contemporaneous to the arrest and made with a permissible area of search. So, ang pasabot sa People versus Estelia, pag na-arrest na nimo siya, you may be allowed to search him and seize whatever is contraband or illegal within his body. When you say permissible area of search, within his area of control. Kung saan man ang area of control? Sa iyang lawas, sa iyang bag, sa iyang likod, sa iyang pockets, sa iyang socks. Pwede po sa brief, actually. Pwede po sa, if in the case of sa girl, pwede sa bra, tanawin, ikapkapan ninyo. But, for example, na siya'y bike na nanaan dito sa unahan, hindi na ito pwede ninyo i-search because ang search ninyo dapat is within his area or her area of control. Naipangutan ha? Naipangutan ha? Right, sige. Ano pa? Search of vessels and aircraft.
About, sir,
Yes.
about sa katong seizure, sir, sa kuan.
Ano sa to?
Nagdepende man siguro, sir, kung babae or lalaki ang kap sa kuan, sir.
Okay. Ang ginabuhat din sa unsa sa tuang jurisdiction is if babae ka, babae ang mukap-kap si muha. If lalaki ka, lalaki ang mukap-kap si muha.
Ang sa katong seizure, sir, ba kung mag-searching sa kuan, kung babae ba ang street area, female, male.
Kung ang akusado is female dapat ang mukap-kap. Wait lang, klaro ba? Tama ba yung question kay wait ha kay medyo choppy imong unsahe. Hello?
Naputol, sir, naputol.
Like for example, dili sa Baganga, gibutang niya ang drugs, lalaki ni siya, gibutang niya ang drugs sa iyang brief. So alangan naman ang female officer ang among ipa-kapkap sa iyang brief, no? So lalaki ang ipakapkap na, a male officer ang ipakapkap na mo na nagkatawa mi kay anak gikansawa na mo to siya na how kay siya mo kapkap og drug sa groin area kay na feel gid daw niya kaayo. I will not tell you who is that police officer kay pero ito gid mong pangatawa. Anyway, so search of vessels and aircraft. So this includes vessels sa seas like imuhang kaning ships, mga ingana, kanang mga port to port na mga vessel. This will also apply. So ginaalaw ang warrantless search dire because again, this is for public safety. And for some other reasons as pointed out by the Supreme Court in the following cases. So a fishing vessel found to be violating fishery laws may be seized without a warrant on two
Sir,
grounds.
excuse me.
Yes, Miss Ana Rose. Miss Ana Rose? Okay, sige. So, a fishing vessel found to be violating fishery laws may be seized without a warrant on two grounds. First, they are usually equipped with powerful motors that enable them to elude pursuit. And second, the seizure would be an incident to a lawful arrest. So, pwede ka mudakop og fishing vessel if kaning fishing vessel tanaw nimo ang motor ani kay paspas kaayo na pwede mong ma-evade or pwede mo takasan. And second, kay tungod pwede din siya i-arrest at that time. So kung makaya siyang arrest at that time, then go ahead, arrest them. Thus, in Hizon versus Court of Appeals, 265 Stra 517, the court upheld the warrantless search of a fishing boat made by the police on the strength of a report submitted by the Task Force Bantay Dagat. Search of moving vehicles. So again, also applicable at checkpoints, also applicable during times of exigencies or times of, when you say exigency, kanang mga emergency situations. A warrantless search of a moving vehicle is justified on the ground that it is not practicable to secure a warrant because the vehicle can be moved quickly out of the locality or jurisdiction in which the warrant may be sought. Alangan, for example, naisakyanan si A, naisakyanan si B, naisakyanan si C. Alangan mo ato pag court, mangayo kung search warrant para i-search ang moving vehicle ni A, B, and C. Daghan kay nakalinya diha. Paspas kay ang movement ba? It's very impractical to file for a search warrant. So that's why the law allows you to search for moving vehicles because it's impractical. Plus, a moving vehicle is a powerful tool to move contrabands from one area to another. So muna, gina-allow nato ang search of moving vehicles. So searches without warrant of automobiles are also allowed for the purpose of preventing violations of smuggling or immigration laws, provided that such searches are made at borders or constructive borders like checkpoints near the boundary lines of the state. So mauna, kung napansin ninyo, ang checkpoints nato kay naa sa boundary. So ang boundary sa Baganga ug sa Katiil kay sa Banaw na area, correct? And sa Katiil and Combal diha sa may inyong intersection or dito sa taas sa may laya ba na siya? Now, one such form of search is that stop and search, which is without a warrant at military or police checkpoints, which has been declared not to be illegal per se, so long as it is required by the exigencies of public order and conducted in a way least intrusive to motorists. If you remember during the time of the COVID-19 pandemic, grabe ni siya kaning stop and search na warrantless search, di ba? If I could remember it correctly, kung gikan kog Davao City, muadto kog Baganga via Comival, muagi kog 15 kabuok na checkpoints na stop and search pirme. So imagine, because that is due to exigencies of public order, meaning emergency siya na dapat i-stop ka and i-search ka because at that time, the COVID virus was very rampant and dapat ang mugawas lang is those who are uppers or allowed to go out because of the nature of your job. So that is the case of Valmont versus De Villa. 178 Skra 211. Any questions so far? Naipangutan ha?
None, sir.
Wala? Okay, sige. Again, here, inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. So this is basically an exercise of the police power of the state and would not require a search warrant. These are routine inspections which, however, must be conducted during reasonable hours. When you say the exercise of police power of the state, money ang exercise nila in order to achieve public safety, in order to achieve public order. Now, when you inspect buildings, when you become members of the Bureau of Fire Protection, it would be your routine job to check the buildings for regulatories involving fire, sanitary, and building safety. Ngano? Kay we do not know, Manggod, when fire would break out, when earthquake would break out. So that's why there is a need to inspect these buildings every year. So alam ka naman, every year, manghayo kang search warrant from the court in order to check this building. Of course, not anymore. Because public safety warrants it. Public safety needs it. So that is the reason why you need not secure a search warrant. But then again, you have to conduct it in reasonable hours. Kami po mag-inspect kag building for fire safety kadlawon, no? Parang pukawan yun yung mga tag-iya sa building, sir, kanang mag-conduct make fire safety 2:30 a.m. Wow. Very insensitive. Okay, so where the prohibited articles are in plain view, kani, please, ikapilag gini siya gi-repeat sa board exam ninyo. Plain view. So objects in plain view, pasabot, naagi sa imong area of sight, kanang mismo naadiha sa imong atubangan, klaro kayo ang kontraband. So objects in plain view of an officer who has the right to be in the position to have that view are subject to seizure and may be presented as evidence. The plain view doctrine is usually applied where the police officer is not searching for evidence against the accused, but nonetheless inadvertently comes upon an incriminating object. So for example, sa checkpoint na punta ha, niagya imong sakyanan sa checkpoint. Pinagibaba ni mo imuhang window. Pagtanaw sa police officer, na dito sa imuhang dashboard, marijuana. Diba? So, that is already a contraband within your plain view of sight. Then, once nakita niyo mo siya in plain view, you need not, di na mo kailangan maghanap ba? Nalala sa mga atubangan. So, all you have to do is seize the contraband and you may validly arrest that person without a warrant. So, klaro ang plain view doctrine. Kanang, lagi sa mga atubangan ba, hindi mo kinahanglan na mag-search. Ang contraband, na mismo sa atubangan. So, that is the case of People versus Musa. 217 Skra 597. All right. The Supreme Court enumerated the elements of a valid seizure based on the plain view doctrine. So, unsa ang requisites or requirements or elements para makaingon ka na mag-apply ang plain view doctrine sa imuhang warrantless search. So first, a prior valid intrusion based on the warrantless arrest in which the police are legally present in the pursuit of their official duties. Second, the evidence was inadvertently discovered by the police who have the right to be where they are. When you say inadvertently, uy, tuara, klaro kayo, di na ako kinahanglan mag-abre o aparador, di na ako kinahanglan mo check sa ilalom sa kama. It's right there and there, your contraband. And lastly, the evidence must be immediately apparent. Meaning, nakita gini mo na, mo na gini siya, marijuana leaves na yun eh. Okay, mo man yung noun sa marijuana leaf. And lastly, plain view is justified the seizure of the evidence without any further search. Meaning, wala ka ni tanaw sa wala ka ni search sa ilalom sa bed, wala ka nag-uncover og certain let's say wala pa siya nakarap, kana nalagi siya diyan mismo sa atong katubangan, and it's all in all of its glory. Nakita nimo ang marijuana leaves. So, mao na diyan na mag-apply ang plain view doctrine. Any questions so far? Nay pangutana?
Sir, ako sir.
Oh, sige.
Sir, ang plain view, ma-apply rin na siya sir sa warrantless arrest kaysa katong sa katong sa search and seizure gani sir.
Sige daw, maghatag
Kaya
na
katong-
example.
Kana sa search and seizure sir kay nag-ana ka atong previous nga topic kay kung unsa la tong nakabutang sa search warrant is mao ra to ang ikuan ikumpiska.
Oo.
Unlike aning sa plain view sir kani sa warrantless arrest kung unsa imong nakita dira mao imong kumpiskahan. Tama ba sir?
Okay. So, please do not confuse when you are given with a search warrant. Kung unsa lang tong, di ba, it has to be described with particularity. So, pag nakaingon gani described in particularity, kung unsa tong inyohang i-search and seize, mo ra gito inyong kuhaon. Na for example, giingon sa inyohan na to search and seize hand grenades. So pag sulod ninyo sa balay, nakita ninyo in plain view ang tawag ani ang hand grenade nakabutang sa taas sa, let's say, sa table. Kaya pwede ninyo ma-apply ang plain view. Okay, you don't need to search naman. When you say plain view, nalagyan diha. Also, mag-apply po siya sa warrantless search. Ano? For example, gi-catch ninyo ning na-moving vehicle. Unya pag-open niya sa iyang vehicle, kay nasa iyang dashboard tong marijuana na leaves yun sa iyang tubangan. So, di na mo kinahanglan abrihan tong mga, di ba naman ay mga abrihanan na sa tubangan sa sakyanan. So, plain view na siya because nakita di mo siya daan sa imuhang atubangan. Di mo kinahanglan mag utingkay so sa tuwa pa para mahanap ning contraband. So you just have to remember the requisites para ma-apply ang plain view. Napay pangutana?
Wala na sir.
Pero na-address ba Pat imong pangutana?
Yes sir, yes sir.
All right, any other questions? Wala na. Naman pangutana?
Wala na sir.
Okay. Moving on. Okay, search and seizure under exigent and emergency circumstances. So ikapalit na siya repeat na ko ganiha. In People versus De Gracia, the raid of and the consequent seizure of firearms and ammunition in the Eurocar sales office at the height of the December 1989 coup d'etat was held valid, considering the exigent and emergency situation obtaining. The military operatives had reasonable ground to believe that the crime was being committed and they had no opportunity to apply for a search warrant from the courts because the latter were closed. Under such urgency and exigency, a search warrant could be validly dispensed with. So in People versus De Gracia, ang ilahang pagdakop, pag-search and pag-seize sa mga firearms and ammunition without a warrant was justified, and the Supreme Court said valid siya because it was at the height of a coup d'etat and the courts were closed. So unsa mo na pag-search sa kaning mga kaning area na ni if closed ang courts, and plus experience would tell you na during coup d'etat, di ba namo ginay gubot. So how do you prevent that gubot? Dapat ma-address yun the situation. You have to seize and take these firearms from the malefactors. So please remember the exclusionary rule. Article 3, Section 2 states that evidence obtained in violation of Section 2, Article 3 shall be inadmissible for any purpose in any proceeding because it is the fruit of the poison tree. Di ba na-discuss naman nato nina, you already know this fruit of the poisonous tree from your evidence na subject. So, if you're able to retrieve evidence illegally, then you cannot produce it in court also because it is already tainted ba with invalidity. So dapat di na siya ma-present in court, dapat ay mong abogado mo object kay tungod fruit of the poisonous tree na siya. Bunga ng nakakalasong sanga, tree is tree, puno. Any questions so far?
Wala, sir.
Wala. Okay, so remember for
Wala,
example, nikalit lang kag sulod sa balay, wala kay search warrant, nga nakita nimo dito sa sulod sa balay na ay contraband, let's say na ay shabu. Nya nag-file mo case against that individual. This is already a fruit of the poisonous tree because wala man kay search warrant. You have no right to search the premises of that house. So any evidence obtained from there cannot be used against you because it is a fruit of the poisonous tree. Klaro ha?
Yes, sir.
Okay. So muna kong giingon na bagong gawas within this year, it was just promulgated, it took effect in August 2021. Why? Because there are a lot of reports on human rights violations. There were a lot of reports na nanglaban daw ang akusado. So, ayun, ang ginawa ng police, pinatay. But truth be told, di pala ganun ang situation. It was the other way around. It was the police officer who was the aggressor and not the accused. So muna, gigawas ning rules on the use of body-worn cameras in the execution of warrants. So please remember, this is under Administrative Matter number 2106-08-SC. So it is known as the rules on the use of body-worn cameras in the execution of warrants. So klaro kayo there is a scope and applicability, meaning when will this apply? The rules shall apply to all applications, issuances, and executions of arrests, search warrants under the criminal procedure. This will also apply to warrantless arrests. So in short, tanan. Mao na reason karon na because of certain, and not just certain, due to heavy reports on human rights violations. What time is it? Okay. So under here, you have your definition of terms, you have your ARD or the alternative recording device. This is an electronic camera system, which is not a body-worn camera, capable of creating, generating, sending, receiving, storing, displaying, and processing audiovisual recordings, and may be worn during law enforcement activities. So, mao ni ang gamiton nimo as substitute if wala kay body-worn camera. So, the general rule is you have to wear a body-worn camera. So, this is an electronic camera designated to law enforcement units for creating, generating, sending, receiving, storing, displaying, and processing audiovisual recordings that may be worn during law enforcement activities. So data custodian, muna siya ang officer of the law enforcement agency implementing the arrest or search warrant who has the responsibility to store and safekeep the data recorded from the body-worn camera. Okay. Yan ito mag-usahan na. So this is an example of your body-worn camera. Ano yung gina-prescribe sa Supreme Court. So, the body-worn camera should be ano ba tawag yan? Should be placed at a conspicuous area sa imong body. So, ang ito nila is muna ni kani siya. Diya sa imong heart banda. Wala siya. Diyan mo mabutang dapat ang BWC. Now, unsay mahitabo if wala mo nag-use of body-worn camera or ERD, you will be liable for contempt of court. Saan yung contempt of court? So, it has been defined as a willful disregard or disobedience of the public authority. So, in its broad sense, contempt is a disregard or disobedience to the rules or orders of a judicial body due to disorderly behavior or insolent language in its presence, or so near thereto as to disturb its proceedings or to impair the respect due to such a body. So in its restricted and more unusual sense, contempt comprehends a despising of the authority, justice, or dignity of a court. So, mao na very important ang use of body-worn cameras nowadays kay if dili mag-follow ang police force, they will be cited for contempt. Now, the problem nowadays is walay nag-release ang Supreme Court og ing-ani na rule, but walay budget ang PNP para mo-procure og body-worn cameras. So, pataka puding Supreme Court mag-release og unsa ba rules. So, ang ginabuhat sa ato ang jurisdiction na sa Davao Oriental is that they are using alternative recording devices. So, kalong ARDs. So, ilang ginabuhat, cellphone ang ilang ginagamit. But, of course, ayaw gamita tong mga Nokia ninyo na recording device kay hanap-hanap gito siya. So, maglisod gitag decipher sa imong video ana kung Nokia imong gamiton kay kinaraang kupong pato siya na unsa na camera. Gamitan pud kanang mga high quality HD kung pwede ka ng 4K ba na siya? Ang recording device nimo ba? So, that's it. So, let's bear this in mind na these are the new rules when it comes to implementing search warrants, implementing warrants of arrest, or implementing warrantless searches and arrests. In short, at all times, dapat naakay body-worn camera or dapat naakay alternative recording device. So that ends our lecture for today. Any question?
Wala,
Salamat
sir.
kayo, sir. Salamat, sir.
Wala? Okay.
Wala.
Na, sir.
Okay, basic. Thank you for your participation and
Report na mi.
see you on Tuesday.
Welcome, sir.
Okay.
Sumuro ka diyan.
Sir.